Well, breaking news at this hour, the Bombay High Court has stayed the minimum alternate tax order on Aberdeen Global Emerging Markets. Remember, first you heard from Bloomberg TV India when Aberdeen had moved and filed a petition in Bombay High Court. That was yesterday. While it was scheduled to be heard on 8th, the matter was mentioned before the court today. The court has stayed the and granted essentially an interim relief. They have stayed the operation of the assessment order that was issued to Aberdeen on the minimum alternate tax issue. In fact, they have asked the department to reply with to file its reply and to hear the matter on June 22nd. And now this, of course, is the first of in the several cases that we will see coming across in the legal forums as far as the challenge to the government's minimum alternate tax orders, or the MAT tax orders that have been issued, or notices that have been issued to FIIs and FPIs. Aberdeen moved in yesterday, mentioned the matter, and has got a stay, is what we have just learned. The Bombay High Court has granted them the stay. The Bombay High Court has also admitted their plea against challenging the MAT notice that has been issued by the government to them. But there are other host of these FPIs or FIIs to whom the notices have been issued. Those will be taken up tomorrow, is expected or slotted to be taken up tomorrow. Could perhaps be something that they would also be seeking as far as the initial stay on the assessment orders, and also as far as the notices that will be issued on them. Remember, this issue has been taken the storm in terms of the government's intention, whether the government is walking the talk as far as the entire taxation simplicity and the taxation issue is concerned. Only last week in the finance bill, that is for the future course, of course, the finance minister clarified on the MAT issue, where it widened the entire ambit of MAT. But as far as those which are there for the current period, that of course is something that still have to see the legal, go to the legal fora to see. We are joined by now Ketan Dalal, a well-known tax expert in the country. Mr. Dalal, thank you so much for joining us at Bloomberg TV India. Do you see this perhaps in the expected lines of the interim relief that that Aberdeen was seeking in terms of the order or the notices of the government?
I think there has been quite a bit of soundbites over the last couple of months on the applicability of MAT to foreign companies. It's not just FIIs, and I think the preponderant view, and certainly my view, is that MAT was never supposed to apply to any foreign company. It was always supposed to apply only to domestic companies. And considering not just the wordings of the law, but even the logic of the law, at least one would have expected that there would be a stay, and there is a stay. Of course, that does not mean that the High Court is agreeing with this matter on merits. That remains to be seen. But at least for the time being, this is some relief and possibly some indication of the shape of things to come. But as I said, one has to wait till there is finality, and also remember that there is the Castleton matter, which is in Supreme Court, and which they will, I think we are hearing this matter in August. So unfortunately, there is still some time to go before that, and to that extent, some uncertainty will prevail till then.
Mr. Dalal, but just to, not really trying to preempt there, but this is perhaps the first step. The other FIIs and the FPIs who have knocked the doors of the Bombay High Court would also be seeking. So would it be fair to expect that, and we do not know the exact contours of each of whether there are similar notices, or, whether there is a difference in each one of them. And so therefore, would it be fair to, sort of expect that it would follow the same line as it has done for Aberdeen today?
Yeah, I think a couple of points there. One is, yes, I think it would be fair. But also, you mentioned about whether it is similar or not. But I think conceptually it will be similar in the sense that the shorter question of law, see, this is not very factual. I think it's more of a legal question. I mean, the short question is, does MAT apply to a foreign company at all? And foreign companies include FIIs. And I think it does not apply to foreign companies at all in the first place. And therefore, from that point of view, should not apply to FIIs also. So I think, yes, it would follow a similar pattern, and I don't think everybody will go to the High Court. So I think the tax department would, suppose they were to issue, let's say, reassessment notices. They would possibly hold that for some time and wait for the outcome of this. And hopefully, if this goes favorable, and I do hope it does, then the question of issuing those notices also should not arise. But unfortunately, till the time there is finality achieved on this, this unfortunate controversy, which honestly should never have arisen, will keep international investors and portfolio investors, private equity, everybody, unfortunately guessing till the time this has come to rest.
Mr. Dalal, as far as the Castleton case is concerned, yes, we understand that the Supreme Court has set August 2015 as the date for that. That also, of course, will take some time. There will be a long-drawn hearing. The government is also saying that they will abide with what Supreme Court will come out with. So essentially what we'll see, the parallel course, while the Bombay High Court looks at specific cases and therefore the interim relief to the notices that have been issued right now, Supreme Court will be the finality that even the Bombay High Court or the other courts will have to really look for. And so therefore would it be then prudent for the government probably to club it together, because it's a question of law even at the Bombay High Court under the writ?
Yes, but the problem is that these are lying before two different fora. I mean, of course, the Bombay High Court could possibly say, look, we will decide it after the Supreme Court, because then if the Supreme Court decides it, then ours would be just consequential. But as I said, these are in two different fora, and potentially the Bombay High Court could decide before that. And of course, then the Supreme Court, Castleton matter, will achieve the finality. Incidentally, by the way, although this is not something which is widely known, the Castleton is not an FII matter at all. It's a normal foreign company. But and therefore, I'm saying this is just not an FII matter. It's a much broader issue. Although, of course, from a capital market standpoint, the FII gets more visibility. But to answer your question, yes, it could have otherwise been clubbed together, but being in two different fora, it is technically not possible to club it, so to speak.
Mr. Dalal, while you mentioned that, this issue should have never happened in the first place, but would you be, there were some people who would term it that perhaps this is the Vodafone movement of the NDA government. Would you agree with that?
Frankly, I don't think these kind of decisions are taken at the levels of the government, at senior levels of the government, because what seems to have happened in this case, at least in this kind of cases in the FII matter, is that at the assessment level, a few decisions were taken like that, and then it snowballed into a major controversy. It's sort of bottoms-up situation as opposed to a top-down situation. And I don't think it had anything to do with the government per se. But of course, because it is broad-based now, of course, people at the highest level are involved. So I think it sort of just emanated from the groundswell of a few tax officers taking the view that they did, rightly or wrongly. And as I said, it has then snowballed into a major controversy.
All right, Mr. Dalal, stay with us. We are also joined by Puneet Shah of KPMG. Puneet, if you could give us your thoughts in terms of the development that has just happened with the Bombay High Court, granting interim relief as far as Aberdeen case is concerned on the MAT issue. What is your thoughts in expected lines? Would you say so?
I would agree with that. I think it was absolutely on expected line. I think the law currently doesn't support the contention which is taken by the tax office of levying MAT on some of these FPIs or FIIs, let alone the FIIs from the treaty countries. But if you look at the other FIIs which are not from treaty countries like US and UK, which are not, so to say, protected by tax which India has entered into, even there, the current income tax law doesn't support the levy of MAT as such on these FIIs, because they do not maintain their books in India, and did not prepare the financial statements in India, and therefore it would appear that levy of MAT would not be in accordance with the law. So it's an interesting development. Clearly, I think, to my mind, on anticipated lines.
Mr. Dalal agreed with me when I said, would it be fair to assess that in the coming days, when we are seeing other such FIIs and FPIs moving court or their case pending before the Bombay High Court, which is expected to come as early as tomorrow, would it be fair to assume that they would be following the same line perhaps, or given that, or do you think that they would be different or be taken case by case basis?
I think they would follow the same line. So I don't see any different. I don't see any reason for any different stand to be taken on this issue. It's fairly clear. It's a very limited issue. It's a issue of law. It's a matter of interpretation of law. And if High Court has taken a stand on a particular FII, I would expect that the similar stand would be taken for other FIIs as well.
All right. We're also joined by Sunil Jain of JSA. Sunil, thank you once again for joining us here at Bloomberg TV India. Latest developments coming in as far as the Bombay High Court stay order. I just had word with Mr. Dalal and Mr. Shah of KPMG pointing out that it is, of course, in the expected lines. But when do you see really for the FIIs and the FPIs getting the whole clarity and a satisfaction in terms of, there is clarity emerging. We know what the rule of the law is, because clearly it's between the legal forums right now as far as Bombay High Court is concerned. It's looking at different cases, case by case. Then you have the Castleton expected to start from August. But when do you see the entire sort of clouds getting over the MAT issue for foreign investors and FPIs, given that courts are going to have the last say?
For any tax clarity to emerge in a fiscal policy regime, I think the policymakers, the government, the finance ministry is the right body to provide that clarity. Unfortunately, this controversy has ebbed to a point where Bombay High Court has now successfully intervened. An interim stay and interim relief has been granted. But I believe that clarity will emerge once government actually makes up its final it finalizes its position in relation to international taxation and transfer pricing issues, and specifically in relation to how FPIs and FIIs are to be taxed in India, given the importance and given the depth that they bring to our capital markets as of now. So therefore, I expect the government to, firm up its stance, to brief its counsel in the most succinct manner possible, and also in the Supreme Court, once the matter, is activated around August, I believe a consistent stand should be taken. There should not be any contradiction in what is submitted to the Bombay High Court versus what is said in Supreme Court. It is not necessary that one of the two will expire before the other starts or the other gets activated. So therefore, a consistency in the stand is very important. And I think, I hope that despite a heavy backlog of cases at both these courts, we see an early end to this totally unnecessary controversy.
All right. Let me also bring in Bobby Parekh, partner at BMR Advisors, joining us on the show at this point in time. Bobby, you just heard Sunil. My point really is that while this is the development that has happened in the Bombay High Court, interim relief has been granted to Aberdeen. We had Mr. Ketan Dalal and Puneet Shah of KPMG pointing out very clearly that probably the other FIIs and FPIs, as early as tomorrow when their case comes up, probably would be seen in the same light. But the big question really is that the clarity is still some time away. And is it fair, therefore, the FPIs and FIIs to only wait till the final decisions take place in the legal forums, whether it's Bombay High Court or whether it is Supreme Court, as far as this issue is concerned?
So, at least as far as this particular, while I haven't seen the Bombay High Court ruling yet, my understanding is that this ruling was issued in the case of Aberdeen. And My understanding is that the facts in Aberdeen situation are a little different from the facts that probably apply to the rest of the FII. In as much as what the law requires is for the revenue authorities to issue a draft assessment order to the FIIs when proposing any adjustment that they are seeking to make, and for the FIIs then to have the ability to object to that draft assessment if they so choose to before the dispute resolution panel. What I understand is that in the case of Aberdeen, instead of issuing a draft order, they issued a final assessment order. And that is perhaps what Aberdeen challenged before the High Court. And the stay may have likely been granted on the basis that there was an error committed by the Revenue Department in issuing a final order and denying Aberdeen the ability to remedies that access to remedies that it would have available if a draft assessment order had been issued. And it's possible that the High Court is not really ruling on the sort of core matter of whether MAT applies to FIIs or not. And so to that extent, I think the Aberdeen position is distinguished or distinguishable from what has happened for most other FIIs, as I understand. And the stay that the High Court has granted, therefore, may not be indicative of any sort of even preliminary thinking that the High Court may have in relation to the merits of the matter.
That's a very important clarification, Mr. Parekh, that you have provided us with, and perhaps what you're saying is that given that there is a technical issue in terms of the error that has been made, it wouldn't be fair really to expect that the others will follow soon, because the entire issue is whether FIIs or FPIs are subject to MAT is still open, and probably that will take precedence when the other cases come up before the Bombay High Court.
That's right.
All right, that's an important clarification really coming in. But Mr. Parekh, overall on the entire issue with regard to that, would you agree that, given that the government has said we'll wait till what the Supreme Court decides on the Castleton case, which again is not really an FII and FPI issue, but a foreign company issue, it has a broader scope in that. But the fact that whether a tax regime of a country should be dependent on the clarification or on the decision of the courts versus the government is the point that Sunil was trying to make. Sunil Jain, a partner at JSA, would you agree with him, or what is your view with regard to that?
Well, I think that my view is that it would have been much better if the government had just clarified its intent position rather than to have taken the approach that it did. I think that would have been a much more elegant and a constructive way of approaching the situation rather than the way that things have played out. But we are where we are, and I think that it's clear that the government's position in terms of what it will clarify and what it will not clarify or what it will do is now pretty much cast in stone. So they have said that we will not do anything for the past. We have clarified what the law is going forward, and anything to do with the past will be determined by whatever decision the courts take. So we have no choice now but to really hope that the proceedings at the Supreme Court get expedited as much as possible, and therefore a ruling gets issued on Castleton as early as is feasible, so that the position for the FIIs can also be resolved based on whatever the Supreme Court rules. Now, the fact is that Castleton is not an FII, and it is just an investment holding company. But the principles, I think, would that will determine whatever the Supreme Court rules in Castleton's case. It should be possible to extend them to FIIs as well, because Castleton, as a fundamental point, is Castleton as a foreign company, is it liable to MAT or not? It is a foreign company which only holds investments in Indian securities, which is what FIIs also do. And it's a foreign company which does not have any place of business in India and does not require to maintain books of accounts as per the Indian Companies Act, which is also the case with most FIIs. And so I think the principles that will be determined in the case of Castleton will equally apply to FIIs. And so although Castleton is not an FII, the ratio of the Supreme Court's decision in Castleton's case should extend to cover FIIs as well.
Do you think this entire issue of MAT will be a big question mark on the government, whether it's walking the talk as far as bringing in tax certainty, and therefore would be a big question mark really for the as the government gets ready to finish 1 year of its term?
Yeah, so like I said, I think that I mean, this is only my view, but I think in my view, this could have been better handled, and there was a more constructive way in which it could have been dealt with. Really, what we are talking about with the issue that we are looking at is a matter of government intent, and the Supreme Court will also interpret the sections, but it will also consider what the intent of the Parliament was in enacting the MAT provision. And if it really boils down to intent, then I'd say that, it's the intent of the government. So if the government wants to clarify intent, it can. And why does it need a court to interpret what its intent was or should be or things like that, when it's much easier for the government itself to clarify intent. And the fact is that the government has clarified intent by exempting the FPIs from the levy of MAT effective April 1, 2015. And if that is the intent of Parliament, then why not clarify that intent for the past as well, rather than wait for the court to do so?
All right. Let me get in Puneet here. Puneet, given the clarification that Mr. Parekh just pointed out as far as the Bombay High Court case, and as far as the difference in the Aberdeen case, being it that there was a final assessment order than the draft assessment order, do you then think that it won't be fair to assume that the same course will follow for the others that will come up tomorrow?
Yeah, I agree with that. The facts are distinguished clearly. The same ratio will not apply to other rulings as well. But on principle, clearly High Court will have to decide whether MAT is applicable to foreign investors at all, given the current law, and that would certainly be applicable and would be useful guidance for other cases as well. So yes, I would agree with that.
All right. Thank you, gentlemen. Thank you, Mr. Parekh, Mr. Shah, and Sunil for joining us here at Bloomberg TV India and giving us the entire perspective on this very crucial issue, which we at Bloomberg TV India have been very closely tracking from the beginning as far as how the entire issue is unfolding, both in the Parliament and outside of it in the legal courts and for us as well. Thank you so much once again, gentlemen, for joining us